I told you you were not supposed to drive, that you already killed somebody with. You were not supposed to be behind that wheel.
2 or more persons were murdered by the defendant.
I couldn't keep my kids here long enough to see if they goes, and it makes you feel bad as a mother.
Detroit's police chief held a press conference to talk about the murder of Zambricia Works. Her mother is struggling to accept that she has lost a second child to gun violence.
I feel like I couldn't keep my kids here long enough to see if they goes, and it makes you feel bad as a mother.
46-year-old Gregory Reynolds was arraigned on multiple charges, including first-degree murder for the killing of Zambricia. Police stated that the incident stemmed from a minor argument. As officers launched their homicide investigation, they utilized technology and witness testimonies to identify the suspect. He was taken into custody.
I'm shocked because I know my daughter wouldn't have never been out hanging with him. So I figured they're not really telling me anything. Me knowing my child, she was also aware with somebody and they ran into him, they knew him. And he said something out the way to her and she said, I'm gonna tell my mom.
In court, it was disclosed that Reynolds has a history of criminal behavior.
He does have from 1999, assault with intent to murder.
However, Zambricia was full of potential and had been working over the summer as a junior fire cadet for the Detroit Fire Department.
She just touched us, her spirit, her energy, her love for the citizens of Detroit.
The judge denied the bond for Reynolds.
Allegedly indicated that he told the witness that he shot her because she was going to be calling her people on him, and allegedly he also said he had to finish it off.
Zambricia's funeral is scheduled for August 27th, which is also her birthday, as she would have turned 23.
It's gonna be a birthday. I just want it to be a huge celebration. I don't want nobody to ever forget her, ever.
After the trial, Reynolds was sentenced to 25 to 50 years in prison in April 2023. A judge imposed the maximum sentence for a tragic accident that resulted in the death of a boy from Buffalo. The sentencing turned tense as Judge William Bowler had a heated exchange with one of the defendants. 21-year-old Levon Tartine stood quietly before the judge, awaiting his fate after pleading guilty to second-degree vehicular manslaughter in connection with the accident that claimed the life of Tsunami Filbert in April. Officials reported that Tartine was teaching 18-year-old Brianna Hightower how to drive when she struck the boy as he ran across Porter Avenue in Buffalo. Hightower did not have a license at the time. For some reason, after a brief pause, the driver and passenger switched seats, and when Tartine took the wheel, he somehow struck the boy again, leading to his death. Although Levon Tartine was initially released on bail, it was revealed that he was recently arrested again for possession of marijuana and for driving the exact vehicle with a suspended license, much to the judge's dismay.
I told you you were not supposed to drive. So what it tells me is one bad decision after the another. You didn't learn anything. You violated the law again by driving the same car that you already killed somebody with. You were not supposed to be behind that wheel.
It's not like I was joyriding or anything, Your Honor. I just went to the Chinese place to get me and my kids something to eat.
Did I release you on bail to say that it was on the condition you don't joyride?
The courtroom drama continued as Tartine received the maximum sentence, potentially facing 7 years in prison. The female involved, Brianna Hightower, was charged as a youthful offender and pleaded guilty to reckless driving. She was released after prosecutors demonstrated that she did not carry out the actions that directly led to the young boy's death. The trial has begun for the man accused of a quadruple homicide at a home in Cleveland in 2019. On September 21st, 2019, Cleveland police received an anonymous tip about a possible dead body inside a residence at East 144th and Kinsman Road. When officers arrived, they discovered 4 bodies on the 3rd floor. Attorneys spent hours questioning detectives and a forensic expert involved in the case. Prosecutors meticulously presented the jury with every piece of evidence collected by detectives, including clothing, gun casings, phones, drugs, and a purse. It was evident that the bodies had been there for an extended period.
Yes, on the upper portion of her body, like her torso area, it was advanced stages of decomposition and very little skin to be seen, yes.
The victims in the case were 23-year-old Chris Monroe, 20-year-old DeJean Willis, 19-year-old Ayanna Quitman, and 18-year-old Jasmine Lawson, who was pregnant. Prosecutors contend that the evidence collected at the scene ultimately pointed them to Tyrell Silver as the suspect. However, Silver's attorneys argue that they have the wrong person. The trial is set to continue. The teen from Hialeah, who confessed to killing his mother, appeared in court for the first time since the tragedy. Derek Rosa's case was addressed during the hearing. He remained calm throughout while his family members expressed deep emotions. They have been attending hearings since the incident occurred. Derek Rosa sat in a brown jumpsuit as he faced first-degree murder charges for the death of his mother, Irina Garcia. The first motion discussed was an emergency request by the defense attorneys to inspect the crime scene and measure the apartment where the murder took place. The teen's stepfather opposed this request, arguing that family members had already been inside to clean the apartment. Despite this, the judge approved the inspection for Thursday, allowing only 3 people to enter, while state attorneys and police were prohibited from being present.
The order will allow a 3-hour block this Thursday afternoon. There will be police presence outside the front door. Will not be entering while you're inspecting the apartment. The persons allowed within the apartment will be 1 attorney, 1 forensic examiner, 1 photographer. That's it.
Metro West is housing juveniles as of about the 26th of October, which happens to be the day that Derek was transferred. We do not believe they're equipped right now to do that for him, and we think that they are doing him a disservice.
The second person allowed in for the inspection was Rosa's attorney, who spoke about a subsequent request after the first motion was addressed. They are seeking to have Rosa moved from the adult facility back to the juvenile facility, as he is charged only as a juvenile. However, a hearing must take place before the judge can decide on this request. Dual Blake is an activist who believes the justice system has again failed the local community. Just 2 days after an 18-year-old was granted deferred probation for carrying a weapon illegally, he faced a murder charge. Despite having been caught multiple times with firearms, including machine guns, a criminal district court judge decided to give him a significant break, a choice that ultimately proved fatal. Court documents reveal that Dual Blake has a particular interest in guns, especially machine guns.
Got a guy that has a propensity to run around the streets with guns, and who knows what he's doing with them. Is he robbing people with them? Is he terrorizing people with them?
On March 9th, 337th Criminal District Court Judge Colleen Gatteau offered Blake an opportunity to avoid a felony conviction on his record. If he pleaded guilty, he would receive deferred probation.
They gave him every chance in the world, and they could have thrown the book at him, and they didn't.
For him to be given deferred adjudication on something like that, especially when he's had 3 prior carrying a weapon charges, that's a problem.
Court documents indicate that the court raised concerns about the offer, but Judge Guiteau granted Blake the favorable deal.
I wish I could say she was, apprehensively wrong, but, sadly she was spot on, and Robin Strong ended up paying the price.
Just 2 days after receiving deferred probation, police alleged that Blake shot and killed 32-year-old Robin Strong. The incident occurred at a motel on the North Freeway.
This individual arrived here at the motel along with another unknown male. Once they arrived here, they went to one of the rooms at the motel. There was some type of disturbance there, and our complainant was shot.
My first name Duty, my last name Blake.
This is Blake appearing in probable cause court on April 13th. At this time, he has not yet been charged with murder.
The defendant was driving a car. He was stopped on traffic. The passenger got out and ran. The defendant got out and ran. The officers found a loaded Glock on the front seat, modified to be a machine gun. The defendant had 2 loaded Glock magazines in his pocket.
On April 14th, Blake was charged with the murder of Robin Strong.
Where are we sitting? Another innocent person dead because of the actions of our court system.
Dual Blake is in jail, with bonds totaling $1,225,000. A convicted inmate from Harris County Jail has returned to court, facing accusations of possessing a makeshift knife and plotting to steal a prosecutor in the courtroom. The weapon in question was a 9-inch long shank made of steel. Fortunately, prosecutors reported that they were able to uncover the alleged plan and find the weapon before any harm could occur.
It is concerning that someone can have a device of this measure, concoct a plan, acquire this object, and try and make measures to execute that plan.
26-year-old Victor Guzman appeared before a judge with heavy security measures in place after the state filed a motion to limit his jail privileges. The orders include confining him to the Harris County Jail, restricting his visitation rights to supervised visits, banning incoming and outgoing calls, and prohibiting contact with other inmates. Additionally, he is no longer allowed to buy items from the commissary.
The state brought this motion because Victor Guzman has demonstrated that not only is he a continued threat to society, but he's also a continued threat to the courtroom staff. He's a continued threat to the detention officers that are charged with the duty of keeping the inmates safe, and he's a continued threat to his fellow inmates.
Guzman has been held at the county jail since October 2022 after a jury convicted him of aggravated robbery, resulting in a 20-year prison sentence. However, he has not been transferred to state prison because he awaits trial on 4 additional charges. His new charge involves possessing a prohibited item in a correctional facility. Prosecutors report that the steel shank was found on Guzman, and they believe he intended to use it to stab and kill a prosecutor who is handling his pending cases and previously represented the state in his earlier trial. It remains unclear how he obtained the weapon.
And all I can say is thank goodness the Sheriff's Department was able to capture that item prior to it getting here.
Victor Guzman was sentenced to 20 years in prison for aggravated robbery after being found guilty by a jury. Jonathan Robert Silas is accused of killing a sergeant with the Houston Police Department, but is now out on bond. Notably, this bond is one of the largest in Harris County in recent memory. Silas was not free from jail on multiple felony bonds or personal recognizance bonds when he allegedly killed HPD Sergeant Sean Rios. At that time, he was wanted for not appearing in court for a misdemeanor weapons charge. The 24-year-old Silas, who is an admitted gang member with an extensive criminal record, had his bond set at $750,000 when he was charged with the murder of HPD Sergeant Sean Rios.
I have never, ever seen someone bond out on a total bonds of $750,000 in close to 4 decades. I was shocked.
It's heartbreaking. It really is to think that you kill anyone and claim to be indigent, you claim you don't have any money, yet you come up with $75,000 to bond out of jail. How does that happen?
One condition of Seeley's bond is that he must wear a GPS tracking device, which the county is covering the cost for. His attorney argues that Seals did not know Rios, who was not in uniform and was on his way to work at the time of the incident. Attorney Clay Conrad also claims that Rios was a rogue officer and that the Houston Police Department is attempting to cover up his disciplinary history.
We believe the reason Sean Rios is dead today is that HPD was unwilling to discipline him appropriately on all the other occasions when he stepped out of bounds.
He has got to know he's looking, if he is convicted, of a potential life sentence. So the question is, do I stay in town for that, or do I simply take off?
I got a text message from his ex-wife, and the daughter said, I'll give them all the money I've got if they'll just keep him in jail. That just breaks my heart. I mean, it really does. It's sickening to think that. That poor little girl has to think about this guy being on the streets when she no longer has a father.
Seals is also accused in several drive-by shootings. Only time will reveal whether he will adhere to all the conditions of his bond. Accused of murdering a New York City police officer, Demetrius Blackwell appeared before a judge in a Queens courtroom, where he was met by hundreds of officers from the NYPD. Blackwell is charged with the murder of NYPD officer Brian Moore. Officers from all boroughs gathered, filling the Queens Criminal Courts building. A wave of NYPD blue, present for the arraignment of the alleged cop killer, Demetrius Blackwell.
We'll fill this courtroom to send 2 messages. That you cannot raise a hand to a New York City police officer. If you do, we will not forget. And the second message to this family, we will not forget you.
35-year-old Blackwell is charged with shooting and killing 25-year-old police officer Brian Moore and attempting to kill Moore's partner, Officer Eric Jansen. in May while they were sitting in their unmarked squad car in Queens Village. Moore's parents were in the courtroom as Blackwell pleaded not guilty. His brother and uncle were also there to support him, claiming that he suffers from a mental illness and is not capable of committing murder.
There is no proof. I mean, they don't have anything to pinpoint that he did this.
I know that he has epilepsy and he's had brain surgery.
Just because I'm pursuing mental disease or defect doesn't mean I'm not also looking at making sure they have the right guide, making sure they can prove the elements of the crime. Everything's on the table at this point.
Blackwell, who is facing multiple murder charges, could potentially be sentenced to life in prison. Queens District Attorney Richard Brown stated that Blackwell should never be allowed to walk free again.
The defendant's alleged conduct and his total disregard of law and authority clearly demonstrates that he's a serious threat to society.
Blackwell's attorney claims that his client is bipolar and was on medication at the time of the murder. He is set to return to court in Kew Gardens. In addition to the murder charges, Blackwell also faces charges related to weapons, drugs, and larceny. Timothy Jones Jr. has been convicted of killing all 5 of his children in August 2014. He took the lives of Mara Gracie, Elias, Nathan, Gabriel, and Abigail Elaine on August 28, 2014, at their home in Lexington County. Afterward, he drove around with their bodies for several days before disposing of their remains in a field in Alabama.
As to indictment 2015 GS 320188, 0189, 0190, 0191, 0195, the state versus Timothy Ray Jones Jr. We, the jury, unanimously agree on the existence of an aggravating circumstance. 2 or more persons were murdered by the defendant by act or pursuant to one scheme or course of conduct in the murder of a small child under the age of 11 or younger, and it is so signed by the foreperson. We, the jury, in the above entitled case, have found beyond a reasonable doubt the existence of the following statutory aggravating circumstances, to wit, 2 or more persons were murdered by the defendant by act or pursuant to one scheme or course of conduct, and the murder of 5 children 11 years of age or younger. Now recommend to the court that the defendant, Timothy R. Jones Jr., be sentenced to death.
On June 13, 2019, a Lexington County jury decided in just 1 hour and 45 minutes, concluding that Jones should receive the death penalty instead of life in prison. This verdict came after an 8-day sentencing phase that followed a 3-week murder trial. On November 19, Circuit Judge Cheryl Caracuzzo followed the recommendation and imposed a death sentence on Marlon Joseph for the December 2017 fatal shootings of Khalida Crowell and her daughter, Kyra Inglet, in West Palm Beach.
This process was a qualitative process and not a quantitative one. Understanding that process, this court then assigned an appropriate weight to each aggravating factor and determined they are singularly and in combination with each other more than sufficient to justify a sentence of death as to each count of first-degree murder in this case. Having determined that the proven aggravating factors are sufficient, the court then undertook the weighing of the proven aggravating factors against the established mitigating circumstances. The court finds that as to each count of first-degree murder considered separately, the proven aggravating factors overwhelm the established mitigating circumstances. Moreover, this court recognizes it must give great weight to the jury's recommendation of death. This court wholly agrees with the jury's unanimous recommendation based on an independent review and assessment of the aggravating factors and mitigating circumstances presented. This court finds the aggravating factors heavily outweigh the mitigating circumstances and that death is the proper penalty for the first-degree premeditated murder of Khalida Crowell and for the first-degree premeditated murder of Kyra Inglet. The court further finds that it would impose these sentences irrespective of whether one or more of the aggravator factors were found not to have been proven or sufficient. Marlon Maurice Joseph, You have not only forfeited your right to live among us, but under the laws of the state of Florida, you have forfeited your right to live at all. Accordingly, it is hereby ordered and adjudged that, as to count 1, for the first-degree murder of Carlotta Crowell, Marlon Maurice Joseph shall be delivered into the custody of the Florida Department of Corrections at the Florida State Prison. You shall be confined there until a date certain selected by the governor of the state of Florida, and on that date you shall be executed in a method provided by Florida law. You shall receive credit for 1,053 days. As to count 2, for the first-degree murder of Kira England, Marlon Maurice Joseph shall be delivered into the custody of the Florida Department of Corrections at the Florida State Prison. You shall be confined there until a date certain selected by the governor of the state of Florida, and on that date you shall be executed in a method provided by Florida law. The sentence for count 2 shall run consecutively to the sentence pronounced for count 1, and therefore there is no credit for time served on count 2. As to count 3, for being a felon in actual possession of a firearm, Marlon Maurice Joseph shall be sentenced to a term of 15 years imprisonment in the Department of Corrections with a 3-year mandatory minimum sentence. The sentence for count 3 shall run consecutively to the sentences pronounced in counts 1 and 2. Therefore, there is no jail credit to be awarded on count 3. These sentences shall not only run consecutively to each other, but also to the sentence pronounced in case number 2014 CF 781. The court further imposes all mandatory court costs pursuant to Florida statutes, and those will be entered as a judgment against you. You are hereby notified that this sentence is subject to automatic review by the Florida Supreme Court. Counsel will be appointed by separate order to represent you for that purpose. Marlon Maurice Joseph, may God have mercy on your soul. This court is now in recess.
He was sentenced to death for the murder of Carlotta Crowell and her daughter, Kira England. In this case, the police discovered a disturbing story of deceit when they arrested a woman and her teenage helpers, uncovering a shocking series of events.
So again, the petitioner here does not have any legal right to any further process, and this court lacks the authority to either review the council's decision to deny her a hearing or to order the governor to provide any further process.
On May 1st, 1990, in Derry, New Hampshire, 24-year-old Gregory William Smart was tragically killed by Billy Flynn. Later, Gregory's wife, Pamela Smart, was also charged as an accomplice in her husband's death. Now, the court will decide whether she played a role or not. During the trial, the prosecutor questioned Pamela thoroughly to uncover the reason behind her husband's death.
Essentially, taking part in ruining the marriage that you had for less than a year by having an affair with a 15, 16-year-old boy.
I don't know how my family and friends would feel.
Do you think your family or friends would approve?
Probably not.
You seem unsure.
I mean, I don't think that they would stop being my friends and never talk to me again, but...
No, but the question was whether or not they approve, and you say probably not. Do you have any doubt in your mind that they would look upon this as quite inappropriate behavior for you?
Well, I'm not the first person in America that ever had an affair.
But that wasn't my question. My question was, don't you think they would look at you and say this is quite inappropriate behavior?
Yes.
But if Greg was dead, you wouldn't have to expose his affair, would you?
No. Unless, like, this happened.
And you could keep the affair secret as long as you chose, right?
I don't know that. I don't know that Bill wouldn't have exposed it or Cecilia wouldn't have. Or
And Bill and Cecilia were the only people who were part of your inner circle at this time who knew about the affair.
apparently not. According to Bill's testimony, JR knew, Pete knew, Frank Daly knew, Sarah Thomas knew.
And then you've come into court and now admitted it because all those people know, right?
No. I've admitted this affair because it's the truth, and that's what I'm telling right now.
And now you decided to tell the truth.
Yes.
Cecilia Pierce, on June 13, 1990, you knew about the murder.
Yes.
And that was a total fabrication on your part in order to try and get Cecilia Pierce to talk, correct?
I told her that I had known about it beforehand, which was a fabrication.
And that's what you wanted her to know, so you might be able to get information from Cecilia Pierce.
Yes.
And you now know, testifying, that Cecilia Pierce went to the police on June 14th, June 15th, and gave them all sorts of information on this case, correct?
Yes.
And as you sit here today, you know that the information Cecilia Pierce gave to the police on June 14th and June 15th inculpated you in this crime.
Yes.
So now, testifying before this jury, you say to us, the day before, I told Cecilia Pierce I was involved, or I knew about the murder before, right?
Right.
And is that the first time you ever told Cecilia Pierce that you had anything to do with the murder?
I didn't tell her that I had something to do with it. I told her that I had known about it.
Okay, so why don't you tell the members of the jury everything you told Cecilia Pierce that you knew about the murder?
I just told her that I had I had known about the murder before it was going to happen.
So that's the only thing you told her?
Yes.
Only knew about it?
There was a conversation afterwards.
Okay, what's the conversation afterwards?
I told her that, and she said, how come Bill didn't tell me that you knew about it? And I said, why? You knew about it? And she said, yes. And then she went on to talk about a couple things that I had never heard about beforehand.
Okay, so why don't you tell us what Cecilia Pierce told you that you had never heard about beforehand?
That there was a prior attempt on Greg's life.
During the trial, Pamela's motive seemed evident to everyone. She had been involved in an affair with one of her students, and that was believed to be her reason for the crime.
When we were working on the video, I was told from the beginning from Cecilia that Bill had a crush on me. And I didn't like him at first, but yes, I did. I did start to like him during the filming of the Orange Juice video.
Did you ever tell him anyway?
Yes, I did.
Tell people in the jury how that came about.
Cecilia had said that Bill was talking about me and that she thought that I should talk to him. And I believe he came over to my office and I had told him that I had known he had liked me and that I thought he was really nice and that I liked him too, but that I was married and that I was not interested in having a relationship with him.
What was his reaction to that?
He was surprised that I had liked him. But he didn't really say anything, he just kind of sat there.
I'm not sure if you said this, but when was this, if you recall?
February 5th.
Did you kiss him on February 5th?
No. I told him I didn't like him.
Did there ever come a point in time when you did kiss Bill White?
Excuse me?
Did there ever come a point in time when you did kiss Bill White?
Yes, I did.
What happened between this February 5th when you told him that you couldn't have an affair at that point in time? What changed?
My feelings.
Describe it.
Well, I didn't set out to have an affair with him, but I did. And in February, I believe it was February 27th or something, it was during February vacation also. While I was over his house, we were working on the video. We were in his room and he kissed me.
Light him off?
Excuse me?
Light him off?
No.
Tell us what happened. He kissed you.
He kissed me and then I went home.
Did you talk about the kiss after the kiss?
I don't remember. I don't think so.
Did you ever, after that day, what was the nature of your relationship? How did things go after?
Well, I really didn't want to have an affair, and I was trying to fight my feelings
Were you successful?
up until March 24th.
What happened on March 24th?
Bill came over my house, my condo in Derry,
Was anyone with him? What was going on? Why that day?
because Greg was gone to Atlantic City.
I didn't hear you. Where was he gone?
Atlantic City?
Bill just happened to come over there, or was it planned?
No, it was planned.
Can you tell us about
The planning of it?
it? Yeah. How did it
I said I was going to be by myself. Cecilia wanted to sleep over, and Bill asked if he could come.
When Bill Flynn asked you to come over to your house when President's gone, do you think it's the same as Cecilia asking you to come over and sleep over?
No.
What's going through your mind?
I'm not sure I understand the question.
Okay, so your husband's gone, Cecilia's gonna come over to sleep over to give you company. And Bill Flynn asks if he can come over, okay? Can I come over? I'm Bill Flynn, can I come over? What's your reaction? What's going on?
Yes, I wanted him to come over.
Did you expect that when he was over, you would have sex with him?
Yes.
Did you have sex with him?
Yes.
Did you watch that movie 9.5 Weeks?
Yes.
Did you make love to him?
Yes.
Did you do the thing with the ice cubes?
No. I think he's having a problem remembering where reality began and the movie stopped.
The prosecutors noticed inconsistencies in Pamela's story about the incident, particularly when she described the moment she discovered her husband's death.
I drove up to the house, and I went into the garage, and I went up to the house, and I noticed that the outside lights weren't on. And I remember thinking that that was odd because Greg usually left them on when he knew that I was going to be late. But, you know, I didn't think it was anything major. I just remember thinking it was odd. And I walked up the steps and I put the key in the door, and when I pushed the door open, I turned on the light and I saw Greg.
What did you do?
Well, it all happened in a matter of, like, not even a second, I don't think. And I remember seeing things near him, like a candlestick and a pillow, and I remember the first thing I thought was to go get help. And I said Greg's name, and he didn't answer, and I ran out. It all happened really fast. It's hard for me to remember exactly what order.
Did you know Greg was dead?
No. I didn't know what was going on. I thought that someone was in the house still, though. I remember thinking that to run somewhere else and call the police.
What did you do?
I ran next door, and I started banging on the door, and no one would help me. It would seem like it was taking forever, and I was ringing the doorbell, and I was screaming, somebody call the police, someone help me. And they didn't come fast enough. I mean, they might have, but it just seemed like forever. And so I ran to the next door and started banging on it, and they didn't come. And I ran to the next one, and by that time, the girl was already coming down the stairs, because I guess she had heard me screaming. They let me in the house. They opened the door and asked me what was wrong. And I said, there's something wrong with my husband. Someone call the police.
How long was it?
Like a second. I mean, apparently someone had already called 911 before this man did.
What did you do when the police got there? Do you remember?
Excuse me?
Do you remember what you did when the police got there?
I remember I went back outside the house, and there was all kinds of cars and people had come outside, and I remember everyone was asking me what was wrong. Everyone was saying, what's wrong with him? Is there something, did he have a heart attack? And well, is he having any health problems? And I kept saying that, no, I don't know, I was crying. And someone asked me if there was anyone that I wanted to call. And I said, call Greg's parents. And I gave them the phone number because they live right around the corner.
While this was going on, what were the police doing? You know, what did you see them doing where you were?
I don't know, I was on the knees I was on my knees on the ground, I don't remember. I'm sure they were going inside the house. But
How long was it before the police came up and gave you any information?
before I got any information, the Smarts had arrived. Greg's brother, his mother, his father, in Greg's brother's car. And they got out of the car, and they were all still in their pajamas, and they were like jumping out of the car. And they were asking me, what's the matter? Where's Greg? And I was screaming that I didn't know what was wrong. And Greg's mother tried to go inside the house, but the police, they wouldn't let her inside the house because they were all outside blocking the stairs. And she was screaming that she wanted to get in, and everyone was screaming at me what was wrong, and I didn't know, and I was crying. And then the EMTs or whatever, ambulance came, and 2 men went inside the house. And they came back outside of the house, and Greg's brother said, how come no one's helping him? And everyone was screaming, how come no one's doing anything? And a policeman came down the stairs. He said, because he's dead.
You know what you did after that?
No, I have no idea what happened, except for I remember being at the Smarts house. That was the next thing, and I have no idea how I got there.
Pamela was convicted of being an accomplice to first-degree murder, conspiracy to commit murder, and witness tampering. She was sentenced to life in prison without the possibility of parole. Over the years, Pamela filed numerous appeals to reduce her sentence. However, on March 29, 2023, it was reported that she had lost her final appeal. With no more legal options, her life sentence remained firmly in place.
Notice to state's counsel. Prosecuting officer may be required to furnish a statement, so there is a basic outline of the process.
That is, you're citing to statutes, so those are requirements that the legislature has created, and they do not put any requirements on the governor or council. They put requirements on people who are applying. So that is permissible. It would not be permissible for the legislature to enact a law that would restrict the governor or direct the governor how to exercise his right. In similar fashion, this court, it would be a violation of separation of powers for this court to create standards of review. So for instance, the Farrow case that the petitioner relies on, you have to read that language in the context of the constitutional limitations on the on the judicial branch set forth in the Constitution. So this court could not, the language that the petitioner relies on does not create a standard for determining whether someone could be subject to clemency. So again, the petitioner here does not have any legal right to any further process, and this court lacks the authority to either review the council's decision to deny her a hearing or to order the governor to provide any further process. So if there are no further questions, I would ask that you dismiss the petition for lack of jurisdiction.
Thank you, Ms. Lavardi. Mr. Sisti?
Thank you, Your Honor. Just a couple of quick responses, and I'll sign off. But the Pepin case that preceded Smart's petition, Pepin's out. Pepin had other relief. Pepin had a determinate sentence. Pepin had parole. Pepin had 650-120. Pepin had avenues other than the governor and council. So let's not even mix that up. And with regard to discretion, there was none exercised here. And there's no evidence of it. What's really going on here is that the state is advocating a long, painful extermination of a New Hampshire citizen when our own Constitution says you can't do it. And then they're saying, not only can we authorize that, but you have no place to go for relief. Now, isn't that an interesting thing to announce to the state of New Hampshire, to the folks here, that you have no relief, you can go nowhere, you're condemned. Enter here, ye have no hope. A life without parole sentence should, with that sentence, hitch on to something, and it should be hope. Because if you don't give hope to people inside, you're going to see that it will be problematic. Hope drives people. And what I think I'm really asking this body to do, really asking you to do, is to announce to the governor and council that they should, in the spirit of Part 1, Article 18, take care of the citizens of this state, give them hope. Even those that committed the worst crimes in the world should have hope. Not 44 seconds of taking a vote and denying it, and not the hatred that one counselor can give to an individual that's incarcerated. And as we sit here today, other people have had hope. I can name 4 of them, all co-defendants in this case, that were released in 2005 and 2018, and I assure you, they're watching this proceeding now in the comfort of their own home. So there is hope and there's success. And I'm asking that you give Pam Smart that little inkling, that little crack in the door where she can have hope.
Billy Flynn, who admitted to shooting Gregory Smart, was sentenced to 28 years to life with the possibility of parole. He cooperated with the prosecution and testified against Pamela Smart. After serving 25 years in prison, Flynn was granted parole in March 2015. While Pamela Smart acknowledges her involvement in Gregory's murder, she has not provided a clear explanation for why she did it. YFN Lucci's life, marked by musical success and personal hardship, tells a compelling story of creativity and struggle. A single moment altered his path, leading to a tragic outcome that changed his life forever.
Mr. Bennett comes to your honor out of the 13 counts. 12 of them will be now prossed. He is going to enter a plea to one of them with the court's permission.
In 2020, YFN Lucci, whose real name is Rayshawn Bennett, was involved in a crime in Atlanta, Georgia. He was the driver in a gang-related drive-by shooting that resulted in the death of James Adams and left another man, Kevin Wright, injured. In May 2021, YFN Lucci was arrested after a manhunt connected to a RICO indictment. In court, his attorney presented a plea agreement, but when the plea was explained, he showed no signs of remorse.
All right, so I have the indictment and the plea sheets. Is there anything we need to take up before we begin the colloquy? And is there any particular preference in order? State.
Judge, we prefer, since we have a matter that's a bit outstanding on Defendant Stanley, we'd like to go ahead and take Mr. Bennett's first.
All right.
We're ready to approach the closing bit. And Your Honor has kindly given us the permission to come in here today and address it this morning. But again, to contextualize it with the court's permission, we understand that we are in the 3rd week of jury selection. However, the record should reflect that the court has, from very early on, been encouraging the parties to continue having face-to-face meetings on various issues concerning outstanding motions. And as a result of that, and talking through those issues, there's been a free exchange and a constant exchange of thoughts about a lot of the issues that we can anticipate that would come up through the course of the trial. As a result of that and the free exchange of, for example, although we don't have the burden, we were forthcoming in what our evidence would be, what our experts would say. As a result of that, and the encouragement of the court to continue those discussions, we now come before you with this negotiated resolution. I just felt it was important to contextualize given the unusualness of what's happening.
And as I said to you yesterday, Mr. Findling, I appreciate the context, and I think it helps to establish a clear record. and I appreciate the offer and the context you've given.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you're charged with the following offenses under indictment 23 SC 188921? Count 1, violation of the Racketeering, Influence, and Corrupt Organization Act, which carries a minimum sentence of 5 years, maximum of 20 years. Count 68, violation of the Street Gang Act, which carries a minimum 5 years, maximum 20 years. Count 69, violation of the Street Gang Act, that's minimum 5 years, maximum 20 years. Count 72, violation of the Street Gang Act, minimum 5 years, maximum 20 years. Count 73, violation of the Street Gang Act, minimum 5 years, maximum 20 years. Count 76, violation of the Street Gang Act, minimum 5 years, maximum 20 years. Count 77, felony murder, that's minimum life, maximum life without the possibility of parole. Count 78, aggravated assault, that's minimum 1 year, maximum 20 years in custody. Count 78, aggravated assault, that's minimum 1 year, maximum 20 year. Count 80, aggravated assault, minimum 1 year, maximum 20 years. Count 81, aggravated assault, the minimum's 1 year, maximum 20 years. Count 82, aggravated assault, the minimum's 1 year, maximum 20 years. Count 83, possession of a firearm during commission of a felony, that's 5 years consecutive. The minimum is life with the possibility of parole, followed by 5 years consecutive, and the maximum you're facing under these charges in the indictment would have been life without the possibility of parole, plus 220 years, followed by 5 years consecutive. Do you understand that that's what you were initially charged with in the indictment?
Yes.
Do you understand that the state has agreed to no pros counts 1, 68, 72, 73, 60, 76, 77, 78, 79, 80, 81, 82, and 83?
Yes.
So, Ms. Christian, the only charge under this recommendation is count 69. Is that correct?
Yes, Judge.
All right. Excuse me.
Have you reviewed this charge with your attorney and been advised of the minimum and maximum for the charge the one charge that you're pleading to?
Yes.
And do you understand that you have the right to either plead guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
The defense asked the court to consider Lucci's background and his lack of prior convictions when considering his case.
Mr. Findling or Mr. Banks, would you like to tell me anything about your client and share anything about the plea?
Yes, Your Honor. Thank you, Your Honor. Your Honor, as you've heard, Mr. Bennett is 32 years old. And of course, we've been to you through the course of years. We've been together on this case with Your Honor for years. He is the father of 4 children, who he assumes the task, the welcome task of being their sole provider, and he takes that seriously. It's well documented what his profession is, and that is that he is a professional entertainer. I want to be clear with the court that we just didn't talk to Mr. Bennett and just take his words on these things. We've talked to literally corporate executives in California about him. We've listened to his music. You know, we've been talking to these jurors about listening to rap and hip hop, and we have spent countless hours watching videos and listening to his music, trying to see the connection it has to the case. We've employed the best experts in America on that issue, on the lyrics issue. We've employed the best experts in America on the gang issue. But most importantly, for purposes of our conversation today, and not too dissimilar from really what was presented to you by Ms. Christian, I actually appreciate her explanation of December 10th. And I would ask the court, December 10th, 2020, to really harken back to some of those hearings. I think that the court will notice that Ms. Christian's explanation of it is very different than the state's explanation 3 years ago before she was on the case. And I credit her with the accuracy of that description. I will tell the court, as we've shared with counsel, we hired literally the best civil engineers in America to analyze what transpired on December 10th. And I think it is fair to say from that, number one, not only is it an possible to, with 100% certainty, say who initiated shooting. But I think it's fair to say that the argument can be made by professionals that these other people actually initiated the shooting based on expert testimony. But what's critical about that and what has transpired, and we've been very open with the court, and the state has acknowledged, and that is the other folks that were involved, some of the names, I'm not going to besmirch their reputations, as the court has heard, now have literally open murder cases going to trial. One of them had been charged with criminal attempt to commit murder. These were these other folks. And so there was a lot going on in that particular area at the time. And these are all the things that contextualize why this plea came to fruition at this time. We have really gotten to know our client's family. The court will note that his family has literally sat in that back row, dedicated to him, paying attention, being courteous to the court, being respectful to the court, but being here in support of Mr. Bennett. And I think that's what the court can expect with him moving forward. There have even been people that are involved in the music world that in like fashion have literally been here, sitting in the back, being courteous, paying attention to these folks, to what has transpired here. Your Honor, given the fact that he is 32 years old, given the fact that, as Ms. Christian accurately said, he comes here with no criminal record. I know it's in the discretion of the court for me to ask for a first offender, but let me give you the logistics behind it. I know others have asked, but they've had a bunch of offenses for which they've entered guilty pleas to. Mr. Bennett comes to Your Honor, out of the 13 counts, 12 of them will be null pros. He is going to enter a plea to one of them with the court's permission. I philosophically had the honor of my first assignment was to be assigned to Judge Daniel's courtroom, who wrote the book on criminal law, the original book that we all look at. And he used to say, when I was a public defender, he used to stare at people and go, "It's my honor to give you first offender because everybody deserves a chance to get on the other side. Of course, if you commit any faux pas during that period of time, you will pay the price dearly."
After the plea deal request and extensive negotiations, Lucci expressed regret and apologized to both the victim's family and the court. The judge accepted the plea deal and then carefully deliberated on the sentence.
Based on the presentation of Ms. Christian, the Assistant District Attorney, I find that there's an adequate factual basis for the charges against you. More importantly, based on your responses to her questions, I find you're entering your plea in this case knowingly, intelligently, and voluntarily. At this time, before sentence is imposed, you're free to make a statement, but only if you wish to do so. Would you like to make a statement at this time?
Yes.
All right.
First off, I want to say my heart goes out to my friend James Adam and his family. Also, I want to apologize to my family and my friends for putting them through this stressful process. And I would also like to apologize to the court. And that's it.
All right. Well, thank you, Mr. Bennett. Let me just confirm with the state that the only pending charge in this recommendation is count 69.
Yes, Judge.
And what is that charge?
Violation of the Street Gang Act.
All right. For count 69, Mr. Bennett, violation of the Street Gang Act, your sentence is 20 years to serve 10 years with the balance on probation. The special conditions are that you're to engage in no criminal street gang activity. You're to have no contact with criminal street gang members or associates. You're to have no contact with your co-defendants, Derek Adams, Rondavius Hawkins, Rayvon Boyd, Leroy Pitts, Artez Carter, Malik Stanley, Reginald Carter, DeMonte Thomas, Tadrikas Glass, Justin Ushery, and Victor Meadows. You're to have no guns or replicas of guns. You're to participate in no gang affiliation and or conduct associated with gangs on social media. You must be gainfully employed. And for purposes of the definition of employment, since you are an entertainer, self-employment would come under the context of employment. You're to have no violation of any state or federal law while serving on any portion of this sentence, including any period of incarceration. You're to comply with all rules maintained by the county jail where you are to be housed prior to being transported to a facility within the Department of Corrections where you will be designated to serve out this sentence. You're to comply with all rules maintained within any facility of the Department of Corrections where you will be designated to serve out this sentence. You will waive your right to appeal any and all terms and conditions of this plea agreement and the sentence imposed, as well as any right that you possess in connection with OCGA section 24-4-410. I'd like to ask both Mr. Findling and Mr. Banks if this term is agreed to by counsel as well.
It is, Judge.
All right. If you violate any term or condition of this agreement, including the special conditions, the state will be free to revoke this sentence and recommend any penalty allowed under the law, including but not limited to the maximum sentence provided by law. As a condition of this sentence, the state has also agreed, and I believe this is the first time I've ever seen this, the state has agreed to write a letter to the Board of Pardons and Parole stating that the state will not object to you being released from the Department of Corrections the first time that you become eligible for parole, or after serving 1/3 of your prison sentence, whichever comes first, if you comply with the following conditions. You're to comply with the lawful authority of any and all law enforcement. You're to have no further incidents from the date of this plea in any penal institution. You are to receive credit, and I don't do the credit from time served, but what I will acknowledge is you have been incarcerated since January 13th of 2021 to the present. Is that correct, Ms. Christian?
Yes, Judge.
And Mr. Finley and Mr. Banks, do you agree with that date, with those dates?
Yes, Your Honor.
All right.
YFN Lucci was sentenced to 20 years in prison, with 10 years to be served and the remaining time under probation. He had initially been facing much more serious charges, including felony murder and racketeering, which could have led to a life sentence without parole. The plea deal also includes a provision for early release, allowing him to be eligible for parole after serving about 1/3 of his sentence, with time already served counting toward that. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.